All right, it's a real pleasure to have this panel to go further into some of these interesting issues that we've been thinking about. This panel is going to be more focused on trade and commerce, and we'll hear first from Aditya Bamzai, who is the Martha Lubin Karsh and Bruce A. Karsh Bicentennial Professor of Law at UVA. His research and teaching focuses on administrative law, computer crime law, and national security law. Prior to entering academia, he served in various government positions, including as an attorney advisor in the Office of Legal Counsel. Marty Lieberman in our last panel also served in that role, so we have continuity there, and as an attorney within DOJ's National Security Division. Then we'll hear from Kathleen, Claussen, and Tim Meyer. Kathleen is a professor of law at Georgetown University Law Center. She's a recognized leader in international economic law and procedure and is co-editor-in-chief of the Journal of International Economic Law. Previously, she served as Associate General Counsel at the Office of the United States Trade Representative. Tim is the Richard Allen Cravath Distinguished Professor in International Business Law at Duke at the law school. He's an expert in international and foreign relations law, the co-director of Duke's Center for International and Comparative Law. He previously served as an attorney advisor in the State Department's Office of Legal Advisor. And then we'll get a commentary on these two excellent papers from Ben Heath. Ben is an associate professor of law at Temple Beasley School of Law. His research centers on public international law, investment law, and national security issues of trade. He also previously served as an attorney advisor in the State Department's Office of the Legal Advisor. I think I'm supposed to read a CLA word to you guys. That word is commerce. And with that, I'll turn it over to Aditya to start the presentations.
Thank you so much, Professor Zaring, and thanks to the organizers, to the Pennsylvania Law Review editors, and Professors Goldsmith and Bradley for inviting me to speak at this event. I think that as I was listening to the first panel, I was reflecting on how my paper fits within this symposium, and the first panel had some high-level thoughts on Supreme Court doctrine and where it's going. And I feel that my paper is more of a zoom into a particular statutory scheme and see how that developed, and then try to learn some lessons from that experience. Okay, so broadly speaking, what the paper is interacting with is the relationship between government authority during wartime and other national emergencies and individual rights and the rule of law. This is a question that has long been debated, and my paper tries to address this topic in the specific context of sanctions law, where principles of what might be described as the common law of war, statutory law, and constitutional rights intersect. Let me illustrate the issues with a case that was decided by the Second Circuit in 1966 with Judge Henry Friendly writing for the court. The case is called Sardino versus Federal Reserve Bank of New York, for anyone who wants to look it up. And in that case, what happened is that there was a Cuban national who was residing in Havana who had a savings account in a New York bank that was subject to the Cuban assets control regulations prohibiting unauthorized transfers outside of the United States of property owned by Cuban nationals. And to cut to the chase about the holdings, Judge Friendly flatly dismissed a challenge claiming that the statute at issue, the Trading with the Enemy Act, to which we'll return, violated the non-delegation doctrine, refer back to our first panel, but described as a, quote, substantial contention the argument that the regulations deprived the foreign national of his property without due process of law in violation of the Fifth Amendment. On the latter issue, he described the government's claim that the Constitution of the United States confers no rights on foreign nationals as, quote, so patently erroneous in a case involving property in the United States that we are surprised it was made. But as he put it, the Supreme Court had previously held that what he described as an alien friend is entitled to the protection of the Fifth Amendment's prohibition of taking without just compensation, even when his government was no longer recognized by this country. Notwithstanding those protections, Judge Friendly said, well, in dealing with the property of foreign nationals, the federal government need not be blind to the acts of the country of which the person is a national, because the Constitution doesn't protect foreign nationals from reasonable response to action by the country of nationality. So in his view, the Supreme Court had previously approved wartime seizure of assets of foreign nationals from friendly countries as a means of avoiding the use of the property to draw earnings and wealth out of this country to a territory where it might be occupied by an enemy country. That principle, Judge Friendly said, is broad enough to justify the taking of the property in the case that was before him involving the Cuban foreign national. And that was so even though Judge Friendly acknowledged that the United States was not formally at war with Cuba. The declaration of war, a declaration of war, in other words, was not necessary before foreign nationals could be deprived of property. So it should be relatively clear from this description that the case that I mentioned, Sardino, presented the problem of finding the right balance between the constitutional rights of foreign nationals and the statutory sanctions framework of the federal government, specifically the Trading with the Enemy Act, which I'll talk more about here now. During World War I, between 1916 and the end of 1917, Congress enacted a series of statutes authorizing the president to take control of private property for the nation's use. And the statutes ranged from control of infrastructure to control of infrastructure, including telephones, water authorities, things of that nature. Among the statutes was the Trading with the Enemy Act of 1917, which I might periodically refer to as the TWIA, just to make the presentation go more smoothly. It was described by one prominent commentator at the time as one of the most important pieces of administrative legislation enacted to meet the problems raised by World War I. The TWIA had multiple parts, but in a nutshell, it authorized the president during the war to regulate the property of enemies or enemy allies, and the statute defined enemy to include persons, including corporations, of any nation with which the United States was at war. So if you're following, then you'll notice that TWIA, as originally enacted in 1917, was tied to wartime. So what explains the Sardino opinion in 1917, which applied the statutory framework to the assets of Cuban nationals outside of a formal declaration of war? The answer is that over time, Congress expanded TWIA's role such that the U.S. sanctions regime and the law of emergency more generally applied outside of formal wartime contexts. To give an example, far afield from international diplomacy and conflict, President Franklin Roosevelt used the TWIA to proclaim a bank holiday during the decidedly non-wartime context of the Great Depression. And at the time, people understood that this might have been a stretch of the statute, but in a sense ratifying Roosevelt's actions, Congress responded by amending the TWIA to provide that the president could act during time of war or during any other period of national emergency declared by the president. Using that expanded authority, long before the United States was at war, President Roosevelt froze the assets of nationals of Norway and Denmark on the invasion of those countries by Germany. And the statute was used to freeze Japanese assets and the assets of occupied European countries before Pearl Harbor, as well as for embargoes against China and North Korea during the Cold War. Passed then in 1977, the statute known as the IEPA, the International Emergency Economic Powers Act, provides the modern basis for the expanded framework created by the TWIA. IEPA grants the president expansive powers to control economic transactions during a state of national emergency. And the question my paper tries to grapple with is whether this expansion of what might be thought of as trading with the enemy principles from the formal wartime context to less formalized conflicts and emergencies can be justified on legal grounds. One way that I try to address this question is through a discussion of the justifications that were put forth at the time the TWIA was enacted in 1917. And that question is of some interest because in an important sense, the Trading with the Enemy Act codified pre-existing prize and embargo law, along with the exceptions that the relevant precedents had carved out from the backdrop constitutional scheme. The Act's, the TWIA's principal author was the historian Charles Warren, who was then serving as an assistant attorney general for the United States Department of Justice, and he wrote a memorandum justifying the lawfulness of the TWIA. By the way, some of you may remember that Justice Brandeis cited an article by Warren on the meaning of the First Judiciary Act in Erie Railroad versus Tompkins, so you can revisit your Civ Pro notes for Warren's other significant impact on U.S. law, or one of Warren's other significant impacts. Warren relied on a series of prize cases dealing primarily with ships captured during war that formed the basis of the TWIA and even gave the statute its name. These were trading with the enemy cases. Let me highlight one that's from the War of 1812 that established part of the contours of prize in the American context. It highlights some of the delegation-style issues and individual rights questions that arise, delegation-style issues that very much intersect with our prior panel, although not completely. In the case, which is called Brown versus United States, it was decided in 1814, a vessel owned and chartered by United States citizens was carrying cargo from Savannah, Georgia to Plymouth, England, when it was stopped by an embargo. And after the declaration of war, the War of 1812, the government sought to seize some of the cargo as enemy property forfeited to the United States. In the opinion for the court, Chief Justice Marshall contended that war is not an absolute confiscation of this property, but simply confers the right of confiscation. And what he meant by that is, as a matter of practice, there was a distinction between vessels with cargoes found in port at the declaration of war and seizure of goods of an enemy on land. That was one distinction. But he also reasoned that neither Congress's declaration of war nor any of the statutes that it had enacted authorized the seizure. At times, Marshall seemed to reason that this was some sort of constitutional principle, but then other parts of the court's holding seemed to rest on inferences about legislative intent, the intent of a declaration of war. So that you might think of as being about the scope of delegation, specifically, a conclusion that a declaration of war doesn't confer authority to seize goods that are on land as opposed to at sea. There was a dissent, and the dissent was by Justice Story, who argued that the declaration of war gives a right to confiscate enemy property and enables the power of the president to do that without any other further statutory authority. Brown, which I've just described, was the most famous of the prize cases out of the War of 1812, but there were others, and just in the interest of time, I won't summarize them. The basic point that I'm making is that the TWIA sought to codify these pre-existing case law principle, and it therefore stands as an example of the 20th century codification of common law. In this case, you might think of it as international law principles. And the TWIA also illustrates the potential difficulties that result from such codification. The Foreign Affairs Statutory President, from such codification, in a sense, the later amendments to the statute unmoor the law from its early 1917 constitutional underpinnings and the theoretical bases that Warren put forward, because Congress expanded the authority for imposition of sanctions to the non-wartime context. And arguably, the prize cases were tied to wartime. I say arguably because maybe I'll hedge on that when we get to a series of questions that this statute might raise. Warren's memorandum canvassed these prize, embargo, and trading with the enemy precedents to justify the statute's lawfulness. And it wasn't just Warren, but rather, if you look at the floor debates in Congress about the TWIA, there's an extensive debate about the application of these cases and how they might apply to the context of World War I. And one of the floor managers for TWIA opened the debate by canvassing all these cases and then claiming that from the outbreak of the war, all commercial intercourse, with negligible exceptions, between American citizens and German subjects has been abruptly suspended or revoked. And I'll just note that one of the individual rights implications of that, which was extensively discussed at that time, was German nationals who were, of which there were many, who were residing in the United States. People wondered whether they could even engage in like normal everyday business. And there was a debate about that question and how that would fit within the TWIA. Okay, so that's a little bit of backdrop on the enactment in 1917 of the TWIA. Here are a few thoughts on the cases and their interaction with the current sanctions statutes. First, you might wonder, was the declaration of war necessary in the series of prize cases on which Warren relied on and on which the TWIA was initially built? Recall that part of the reasoning of the case that I mentioned from the War of 1812, Brown, was constitutional, but other parts of the case may be sounded in statutory legislative intent, suggesting that Congress could depart from the defaults established by case law. Second, somewhat relatedly, I think this statute and its subsequent amendments raises the question whether we as a society or the federal government has just shifted from formal declarations, formal invocations of war, to informal conflict, such that the shift from TWIA to the more modern frameworks of IEPA that speak of national emergencies or conflicts is part of a broader shift from relying on formal declarations of war. I think just of that occurring where there's a shift from formal declarations to more functional approaches to the use of military force in cases like the Balkan conflict or in Syria. And recall Judge Friendly's opinion in Sardino about the freezing of the Cuban nationals' bank account and the question whether that violated the Fifth Amendment. In that case, Judge Friendly seemed to acknowledge a shift of this nature. Since the classic cases, he remarked that the world today is not the classical international law world of black squares and white squares, where everyone is either an enemy or a friend. So that sort of speaks to this question. Third, is it possible that some other justifications can explain modern sanctions law, some other constitutional justifications? Perhaps the notion that the government can place temporary barriers to transfers outside the United States, which just don't count as a taking. Perhaps that's one reason. It wouldn't count as a seizure or deprivation, giving rise to due process protections. Perhaps there are some other emergency-style powers built into the due process and takings clauses, which we could maybe reflect on and talk about if people are interested. I'll just close with a quote that comes from the debates over the TWIA in 1917. It's by a representative who said that this war is to be won as much by dollars as it is by men and guns. And the question that I've reflected on as I've done some of this research is that this issue of constitutional protections and emergency or wartime powers remains an important one, and claims of takings or due process violations have arisen now in a number of modern sanctions and other related cases, and we'll, I think, hear a little bit more about that as we go through the day. Thanks so much, David.
Yeah. Great, fantastic. Now we'll hear from Kathleen and Tim. Take it away.
Great. Thank you so much, David. And thanks to our organizers at all levels, on the faculty side and the student side at the school. It's terrific to be back at Penn for this conversation. Of course, thanks to you all for being here at what is a very, very difficult time for many, and just want to recognize those who couldn't join us, given the challenges of the world as we are talking about foreign affairs. But we're delighted to have this conversation today. Tim and I have been thinking about the foreign commerce power for quite some time, and particularly how it intersects with the Article 2 powers of the president. So we have a broader project that's looking at the founding up into the present and trying to interpret this Article 1 authority, some of which will benefit from Nick's important work that he shared with us earlier today. Our concern in this piece of the project is that the statutory foreign commerce authority has reached a tipping point. Put simply, the Constitution grants Congress the power to regulate commerce with foreign nations, but today the exercise of the foreign commerce power resides primarily with the executive branch. So this project is directed toward the reclaiming of that foreign commerce power. Now, we could talk more about why we think that is necessary, but you don't need to take our word for it. There is now quite clearly a bipartisan consensus on the Hill that Congress has given away or otherwise lost much of its authority, and that it should take it back when it comes to foreign commerce. The question really is how to do it. So this is clearest most recently in the context of a Taiwan trade deal. Some of you may have heard of this, that the executive branch negotiated a trade agreement with Taiwan a few months ago without any express authorization from Congress and without any plan to bring that deal before the Congress for approval, despite that it contained binding commitments related to foreign commerce. Again, seems like it should be in the zone of the Congress. But Congress responded on this occasion. It responded by passing legislation approving the deal after it had been signed, and then also setting down certain markers for any future exercise of that authority, any future deal that the executive might wish to bring with Taiwan, which it indicated it would. So legislation was passed that said, we approve of your deal that you did without our approval, but now we approve of it. And if you're going to do another one, here are the things we wish you to do. We want you to bring us the text before you go back to Taiwan. We want to have more conversations about what you're bringing to Taiwan, and so on and so forth. So that's what we've seen in the trade agreement context. Now, interestingly, the footnote here that when the president actually signed that Taiwan bill into law, then there was a signing statement that basically said, oh, we don't like what you're doing here, Congress, about our negotiating authority. We could talk more about that if you wish, but it's very clear that the branches are not on the same page when it comes to the division of power on foreign commerce, particularly in this trade agreement context. There's a similar story that we can tell in the tariff context. Many of you will also be familiar with the tariffs we have on products from China, for example, or so-called national security tariffs that come up in other papers we've discussed today. So there's a similar story there about precisely what should be the design of power between the branches. Congress has yet to make a move on that tariff side, and some of that has ended up in the courts, as we will tell you in a moment. So this article, this particular symposium piece, focuses on 4 developments that have brought us to this tipping point. The first is what we identify as the rise of a foreign commerce bureaucracy, or a trade administrative state, if you will. The second is the claims that are brought by this trade administrative state, by the foreign commerce bureaucracy, that it is not subject to the legislative and judicial controls that come with ordinary administrative practice. That is, in some instances, our trade bureaucracy tries to play it both ways. It will take shelter in administrative protections such as Chevron deference when it's available to it, and then it will claim exceptionalism when it's challenged for exercising some of its other authorities. So these different claims have begun to play out, and we'll talk about that as well. Third is the rise of economic securitization as a self-standing policy area at the nexus of both foreign commerce and national security concerns. Again, something which both of us have thought a lot about, this rise of economic security and how that has contributed to this problem. And then fourthly is this idea of judicial acquiescence that we're seeing from the courts, particularly in the last 5 years, that Tim will pick up here in a moment. So those are our 4 developments as we come into this problem. The rise of the foreign commerce bureaucracy, the way that foreign commerce bureaucracy has reacted in the face of challenge, the rise of economic securitization by that bureaucracy, and then finally the way the courts have responded. So we'll focus on those, but of course there are other factors in this story that we can talk about if time permits. So let me tell you a little bit about the rise of the foreign commerce bureaucracy. There are 2 features that lead to this as we know it today. One is the delegations, the set of delegations that we get from Congress over the years, and we sort of begin to tell that story most clearly at the end of the 19th century, but then very prominently through the 20th century. And then alongside those delegations, you also have this institutional growth, some of which is the direct result of the delegations, but some of which the executive does on its own. So let's start with the first delegation of significance for us, which is the McKinley Tariff Act of 1890. So 1890, this is the first act that allows the president to go do reciprocal trade deals with other countries where there are particular problems, for example, with tariff classifications. Again, we'll sort of leave those details to one side. The point is that in that moment in 1890, you start to see the Congress say, okay, we want the president to go do trade deals to get reciprocal bargains for us in the trade space. And he does. He does do that, and that authority gets renewed over time. This, of course, gets challenged if you are admin law fans, of which many of you are. This gets challenged in the courts, and in Field v. Clark, this comes up. Also in con law, of course, this is another con law favorite, where the Supreme Court says this is permissible. Because to not do this would be to stop the wheels of government, right? So we see the court already sort of give its blessing in those early days. More acts would follow of the same variety. 1934, we get the Reciprocal Trade Agreements Act, renewed repeatedly, that allows the president to go do these trade deals. 1974, we get the more modern version of the Trade Act that allows and encourages the president to go do trade deals, big, comprehensive free trade agreements that we get in the years that follow. So these big trade agreement acts empower the president to do these trade deals, but also really expanded what trade meant. So this is where you start to see the bureaucratic effect, that now we see trade, the regulation of foreign commerce, taking place in a variety of different agencies across the executive branch. Again, particularly in the last part of the 20th century, this occurs. Alongside these delegations that relate to big trade agreements, we also have delegations that relate to foreign commerce and security. Now, over the years, Congress has given the president authority in the context of national security or on the basis of national security to make trade policy by raising tariffs. So you have these go make trade deals that would lower tariff authorities. At the same time, you have these when national security requires it, you can raise tariffs with certain trading partners on occasion. We can also put IEPA, we can put TWIA in this category. We have a number of these foreign commerce, national security styled statutes. So these are the sets of delegations, agreements, and national security related tariffs. And then finally, you have the bureaucracy itself. I mentioned this institutional growth that's taking place, institutional expansion. Some of it's a reorganization styled expansion, but some of it is just simply the nature of foreign trade is moving its way throughout the trade administrative state. Some of it's subdelegations, which we'll hear more about later today. Part of it's practical, but part of it really is pushing the boundaries of just how foreign commerce extends. So by this century now, you get this vast trade administrative state. You go from what was in the mid-20th century a sort of vertical, very carefully organized trade administrative state to one that is now far-reaching with extensive authorities. Throughout this story, some degree of quiet aggrandizement on the part of the executive branch to claim more in this space. And when challenged, as I mentioned earlier, they'll say, well, trade is special, foreign commerce is special, or this is really foreign affairs. And so for foreign affairs, we should be treated exceptionally. Especially that does this when it comes to the tariff authorities. And it's the latter, it's the tariff authorities that come before the courts. It gets to the court, the question gets to the courts most recently in the context of this trade war, the trade war battlefields that we see. Security takes on a very prominent role in this story. And some of these delegations, when they get to the courts, they come under various legal theories. But it's not the claims and the plaintiffs that matter most to us. It's actually how the government responds and the arguments that the government makes to respond to precisely these sorts of challenges that it's seeing. And with that, Tim will pick up.
Okay, great. Thank you, Kathleen, and then thank you as well to all the organizers and all of you. So as Kathleen mentioned, one of the things that is most striking, and this story is probably familiar, but it's perhaps worth laying out, that beginning really in 2017, although we can see earlier echoes of this, the executive branch begins to pick up the statutory delegations that have been around for decades and uses them basically to regulate the domestic economy. And it does this primarily through the imposition of very significant tariffs on imports. And the Trump administration is explicit that the idea here is basically to promote a resurgence in American manufacturing. To the extent that we're talking about the China tariffs, there may be a foreign relations objective there. But I'm going to primarily talk about the quote-unquote national security tariffs on steel and aluminum, which were very explicitly about trying to protect and generate a resurgence in American manufacturing. And as Kathleen said, one of the things that is most striking is that unlike a lot of foreign affairs issues, these economic issues can get into court because typically somebody's paying a tax or a tariff that they don't want to pay, and so they're standing when we don't always see standing in a lot of foreign affairs issues. And so the government is forced to defend its interpretation of these, what are conceitedly very broad statutes. And it's forced to articulate why it thinks its behavior is A, consistent with the statute, and B, constitutional. These claims, the reason we focus on these claims are precisely because we see that they trickle over into other areas, right? So Kathleen has already talked a little bit about the Biden administration's signing statement on the Taiwan deal. Well, if you think in the context of these tariff authorities that you have basically the president has inherent constitutional authority to regulate the foreign commerce and basically to set taxes when those taxes fall on imports, that may very well influence the degree of constitutional power you think you have to negotiate the trade deals that are going to require the regulation of foreign commerce or the imposition of certain kinds of tariffs. So the government's claims in litigation, even if they are not accepted in their maximalist form by the courts, I think tell us important things about how the government thinks of its own role in sort of applying and implementing and executing, if you will, its foreign commerce delegations. The second thing that makes the government's arguments here, I think, particularly important is that we might think that the government is under an obligation. It's not an ordinary litigant. It's under an obligation not to just put forward the maximalist position, that it actually has a duty to respect the separation of powers itself. And so one of the things I think is striking is that this litigation over the last 5 or 6 years really suggests that the federal government is just pursuing a maximalist position on its own power in a way that it's much more like what we would expect a corporation to do than what we might think of a government should do when acting in the public interest. I'm going to talk a little bit, I'm going to focus on Section 232 of the Trade Expansion Act and the litigation over that statute. Section 232 of the Trade Expansion Act is the statute that was used to impose national security tariffs on steel and aluminum, 25% on steel imports, 10% on aluminum imports, as well as their derivative products. And it spawned a lot of litigation. And some of the litigation is constitutional, non-delegation litigation, and some of it challenged the Trump administration's compliance with certain statutory provisions. I think at the outset, before I go any further, it's useful to just make clear that although Section 232 uses the word national security, it is not national security in the sense that we normally use that term. So in defining national security in Section 232, Congress directed the president to take into consideration the impact of foreign competition on the economic welfare of individual domestic industries, any substantial unemployment, decrease in revenues of government, loss of skills or investment, or other serious effects resulting from the displacement of any domestic products by excessive imports, without excluding other factors. It's just a general delegation to impose tariffs because you think there's a problem with the economy. And it explicitly empowers the president to make distributional choices among different sectors of the economy. So when you hear people talk about Section 232 as if it's a national security statute, we should just be clear it's not a national security statute in the way that we normally think of national security, because that's not the statute Congress wrote. So I'm going to talk a little bit about the government's position in a couple of cases and then the resolution of one of those cases. So the first case is a non-delegation case. This case is referenced in Curtin Jack's paper. It's American Institute for International Steel. And in that case, and in full disclosure, I was one of the lawyers that represented the American Institute for International Steel in this case. There was a non-delegation challenge to Section 232. The claim was that definition I just read you is essentially so broad that it just gives the president the power to regulate the economy in any way he chooses. There are also no other limitations in the statute. So the time-based limitation that Nick mentioned, there are no time limitations. There's no limitation on the choice of a measure, whether it's a tariff or an embargo or a license. There's basically no limits in the statute at all. And so we brought a non-delegation challenge. And the government defended on 3 grounds. One was just that they said there was an intelligible principle, national security. The second was precedential, that there was an earlier Supreme Court case that sort of opined on this in the context of a statutory claim. But the third thing the government said was that, and I'm quoting here from their brief, the president's coexistent constitutional foreign affairs and national security responsibilities compel the conclusion that Congress did not enact an unconstitutional statute by adding its Article I authority to the president's independent powers. And so, if we think about this again, I think in light of, particularly in light of Curtin Jack's paper from this morning, it's actually, I think, quite difficult to see what the foreign affairs or national security power that the president has when what we are talking about and what the president at the time was talking about was basically distributional choices about the domestic economy, whether to privilege basically American steel and aluminum producers, or whether to privilege American steel and aluminum consumers, who are ultimately the one who are going to pay these taxes on imports. The second case is a case called Trans-Pacific Steel. This case was a statutory challenge. Prior to 1988, the president would make a finding that there was a national security problem and then would modify at any point in time the particular measure that he imposed. And so these modifications would go on for years. It's very similar to the national emergencies framework, where the president declares a national emergency and then over time uses that initial declaration to sort of modify and establish a variety of legal regimes. In 1988, Congress decided it maybe wasn't so keen on the idea that the president was using this modification authority. Again, very similar to what Congress had done in the context of national emergencies when it enacted the National Emergencies Act a few years before that. And so Congress imposes time limits and says that the president has, after he decides that there is a national security problem within the meaning of the statute, has basically 90 days to decide what to do about it. President Trump imposed the tariffs initially within 90 days, but then well after the 90 days, on a couple of different instances, he did other things. He modified the tariffs. In particular, he doubled them on Turkey for various reasons. And so Trans-Pacific challenged those tariffs, that doubling of the tariffs, as being essentially out of time, inconsistent with the statutory limitation requiring that action be taken within 90 days following an initial determination, which itself follows an administrative process. And the government argued that the president doesn't have to comply with the time limit because the president's, and I'm quoting, the president's authority to take continuing action is at its strongest when the president is exercising powers that are quintessentially executive in nature, such as foreign policy and national security. It's worth reiterating that this is just a tax, okay? It's hard to be more domestic than a tax. The tax happens to be on imports, but at the founding, as I think Nick has reminded us, right, the taxing power was entirely about imports. So there's no question that this is a constitutional power that is reserved to the Congress, and yet we see the government making this maximalist claim that because the delegation involves, I guess it's because it says the words national security, that grants the president some leeway basically to ignore statutory limitations. I just want to say two more things very, very briefly, and then I guess we'll turn it over to Ben. The first is that I think we need to acknowledge that the courts have not just embraced these maximalist claims from the government. In a variety of cases, we talk about a variety of other cases in the paper. In a variety of these cases, the courts either reject the government's maximalist position, or they rule for the government, but on somewhat what at least might be construed as somewhat less maximalist grounds. But I don't think we find this terribly comforting. And so the Trans-Pacific decision, Trans-Pacific runs from the Court of International Trade, which is a specialized court that hears trade cases. Appeals then run to the Federal Circuit. The Court of International Trade said, I can see that Congress amended this statute specifically to add these timelines after the modification authority had been abused. And so these tariffs were imposed out of time and therefore struck them down. And the Federal Circuit reversed, and the Federal Circuit said that basically it was consistent with the statute for the president to just announce within 90 days that he had a general plan and to modify that plan accordingly over time, more or less indefinitely. And the court cited the president's pre-1988 practice of modifying when there were no deadlines in the statute as evidence that Congress would have intended the president to have this modification authority. Again, if I could just tie this into Kurt and Jack's paper, and particularly Kurt's comments about historical gloss, This is a really difficult situation in which historical gloss essentially acts as a barrier to Congress's effort to reclaim its foreign commerce power. Congress had pretty clearly imposed these time limits exactly to prevent this expansive use of modification authority, to require that there be repeated administrative process and potentially consultation with Congress over the imposition of these kinds of measures, and the Federal Circuit just reads it right out of the statute. So we conclude the paper, and we can leave this perhaps for Q&A with a variety of sort of prescriptions for how Congress might, in this challenging environment, think about reclaiming the foreign commerce power. So we have some suggestions for agreements. The one suggestion that I'll just highlight here in light of our comments is that it might be very useful to shift the appellate jurisdiction over the Court of International Trade from the Federal Circuit to the D.C. Circuit. And the reason for that, it's very important that there be a single, the Court of International Trade is functionally a district court. It's important that there be a single district court that has jurisdiction over tariff cases so that tariffs are not being administered in different ways around the country. So there's an important uniformity goal here. But the Federal Circuit is a court that is almost entirely a patent court. They deal with over half their docket is patent cases. And a few years ago, one of the judges on the Federal Circuit said that actually understates the amount of time they spend on patents, that they actually spend over 80% of their time on patents. It does not make a ton of sense to have a specialized patent court overseeing what are basically administrative law and statutory interpretation delegations that affect basically the way the executive branch is regulating the entire economy. That kind of thing is the bread and butter of the D.C. Circuit. And so one of the things we think would really just go a long way towards normalizing oversight of congressional delegations in this space is just subjecting this to the ordinary administrative process that applies to all other kinds of domestic economic delegations, have them run through the D.C. Circuit. And so I'll stop there.
All right, two very interesting and intriguing projects. Now let's hear some commentary about them from Ben Heath.
Great, thank you. And thank you for the opportunity to be here, and to the organizers and the students, and to absent friends. I really appreciate the opportunity to talk to you guys. So these papers are very different. I think what connects them is the broad idea of commerce and the larger question of economic securitization that we're sort of living through today, that we've treated as a bit of a 21st century phenomenon. But as Aditya's presentation ended, the idea that warfare is economic, and maybe the economic is warfare, is a lot older too. And so there are some connections there. I'm going to treat the papers largely separately because I think they merit that. And I'm going to start with Aditya's, which we can sort of then use as a case study for developing some of the broader themes in y'all's paper. So in Aditya's paper, there's sort of there's two concepts that are currently at play, and I'd like it to become more of a triad. I think that's the main theme. The two concepts are the distinction between wartime and peacetime, which has become blurred, which has become problematic, et cetera, and the problem of forfeiture or something like it, of the government taking over assets from private parties. And I want to introduce a third concept, which is the distinction that's very important to a small group of national security lawyers, of which I briefly was one, of freezing versus seizing, right? And I think that concept needs to play a bigger role here, and it doesn't necessarily change the story, but it enriches it. And so to give you guys a very concrete illustration of what I'm talking about, last year, the constitutional law professor Larry Tribe, with a student co-author, wrote an op-ed in the New York Times arguing that existing statutory authority is available to seize frozen Russian assets, right? These are assets that were already frozen, but to seize them and then transfer them to compensate victims of the aggression in Ukraine. And the uniform reaction sort of across the ideological spectrum of national security lawyers, including me, was to be absolutely apoplectic. That these two actions are different. They have different legal bases and different foreign affairs implications. And there was a lot of writing on that in the blogosphere. But we also see this, if we go back through the legislative history, starting where the paper starts, we can actually see this distinction being in ways respected, but in ways that ultimately open up a large space for economic warfare in a certain kind of way. So that's what I'm going to talk about. So I'm just going to get a little technical, but I ran through the statutes yesterday, and I thought this was interesting, and I thought I would share it. So the Trading with the Enemy Act, or what I will accidentally call TWIA from time to time, was adopted in 1917. And Section 5B, which the paper rightly focuses on, is grants to the president what I'll call the regulatory power. It's the power to freeze assets, to investigate, and to prohibit transactions. And then the power to what I'll call the forfeiture power, the seizure power, the transfer power is much more limited. And to my reading yesterday, as I was running through this, shows up largely in sections 9 and 11 of the statute. And really what happens is the assets, once frozen, are transferred to a custodian who holds them, may do a lot of things with them, acts as a common law fiduciary. And then at some point around the end of hostilities, there may be claims to those assets by people who are owed those assets by the foreign party or have been injured by the foreign party and want to recoup their injury based on those assets. And those claims will be adjudicated through a process, and then the assets will be divvied up and returned to whoever is owed. And that is really the family resemblance with prize law. I'm not a prize law expert, but that sort of seems to be the carry through there. And then in 1933, after FDR's bank holiday, Congress adopts the Banking Relief Act. And it expands the regulatory power, the power to investigate, regulate, and prohibit transactions to domestic emergencies. And again, I'm happy to be corrected if I'm wrong, but the seizure power, the forfeiture power, is much more limited in this new context. And so, for example, in Section 3 of the 1933 Act, there is a rule that empowers the president to require the confiscation of gold bullion, gold coins, right? And this requires the government to compensate the gold owner with currency. And moreover, not just for the value of the gold, but actually for transporting the gold, for ensuring the transport of the gold. It's a way to sort of provide a fair market value compensation for the taking. It's a way to avoid takings problems, right? And then in 1941, you have the First War Powers Act, which amends the TWA and the TWIA, and gives us language that we sort of have now incorporated to modern sanctions law. You get the regulatory language for foreign exchange transactions, and you get a new form of regulatory language that is a laundry list of things the president can do. The president can investigate, regulate, direct and compel, nullify, void, prevent, or prohibit any transaction, yada, 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 right? And then also, this is again all during wartime, the president also separately in another section has power to vest property as directed under presidential regulations. That's the forfeiting power. So now the same stuff that is being frozen can be vested as the president thinks appropriate, but it's all during wartime. The banking relief stuff is separate. And then, there is other periods of national emergency. That then gets limited in 1977 with the International Emergency Economic Powers Act, or IEPA, as you've heard it called today. So IEPA limits the Trading with the Enemy Act to wartime exclusively. It removes the national emergency idea. But it maintains, in wartime, the broad vesting authority. So once wartime assets are frozen, they can be vested, right? But for peacetime sanctions, we're limited to regulating or freezing, and we use that same laundry list: investigate, regulate, direct and compel, nullify, void, prevent, or prohibit transactions, right? And so for peacetime sanctions, all you can do is freeze assets. You cannot take them and reallocate them to someone else. The last data point in my very stylized and short legislative history of this stuff comes from 2001, and it's the USA Patriot Act. At the suggestion of the Bush administration, the Congress grants authority to confiscate assets frozen under IEPA. So not just TWIA in wartime, but under IEPA. And the confiscation authority sort of reflects the broadened definition of what we think of as warfare in today's context. When the U.S. is, quote, engaged in armed hostilities or has been attacked by a foreign country or foreign nationals, the assets of those entities may be confiscated. So it's useful in a limited context, but most of the sanctions that appear in the IEEPA context are not really covered by this limited transfer and seizure authority, right? So what we have here in this story, at least from what I see, is Congress and the executive in some ways attempting to negotiate sort of a limited freezing power for peacetime, and while expanding the power to seize assets during wartime, right? And there is still a wartime, peacetime binary, although it's been complicated by this new idea of armed hostilities and attacks by foreign nationals, even if it's not ordered by the foreign government, right? So these are new powers. Of course, the idea of the freezing authority being limited has changed in recent years, right? So we're dealing with, like, we have assets frozen under the Trading with the Enemy Act, dealing with Cuba that have been frozen since 1959, right? We have assets with Iran that have been frozen since 1979. And then these assets have been depleted through various means, which we don't really have time to talk about, but is another part of the story. And of course, but nonetheless, this freeze versus seize distinction remains important to a certain segment of the national security establishment, that most of the time what we're doing is freezing. We are not seizing, and we need special authority to seize, and it triggers special international law problems, as you've recently seen in the ICJ's certain Iranian assets case. Moreover, there's no reason why the Fifth Amendment or international law needs to track the freeze versus seize distinction, right? So the first case I teach in civil procedure is Snyadoc versus Family Finance Corp. From 1969, which decides that a pre-judgment wage garnishment, right, just a temporary garnishment of wages, hold them in escrow to satisfy an eventual judgment, is a takings problem. It's a taking of the liberty to use your wages during the time that they are in escrow. And so therefore there is a constitutionally protected interest here, and due process issues arise. We see the same thing in the Sardino case that the paper mentions. And the government's first argument, which is dealt with in footnote 20 to the paper, was that the government's merely freezing, not seizing. And this argument was dealt with by saying, like, well, the due process clause talks about deprivation. And if we're freezing assets for a significantly long time, we're depriving you of the use of those assets. Due process concerns arise, right? And this is also reflected in the third restatement of foreign relations law, which attempts to carve out some space for IEEPA. Note 7 to section 712 of the restatement says that IEEPA seizure is probably not a taking, but it can be so if the seizure is for an extended, or the freeze is for an extended or indefinite period of time. And we're certainly living in a post-1987 world where a lot of assets have been frozen for an extended or indefinite period of time. So we do have takings problems. So the paper is a little short on present-day implications, and so running through this history, a couple of implications pop to my mind. First is it gives a sort of sense of the drift that we've seen through the attempt to codify and then adjust the codification of common law, right? What begins as a wartime, peacetime binary, and what you can do with assets during that binary now has become this trinary, this triangle relationship between freezing and seizing, taking and not taking, and wartime and peacetime, with this idea of armed hostilities in the middle. And it reveals the disconnect between U.S. government practice, which is really concerned with this distinction between freezing and seizing, and the constitutional and international law around it, which may not be so concerned. And finally, it also points to an interesting irony in a case like the Sardino case, right? If we do think of freezing as a more limited intervention than seizing, and some of us seem to be committed to that for how we reacted to Professor Tribe, then it's interesting that a case like Sardino relies on precedents about seizing to justify the freezing, as if these are not different operations, right? And so that's about as far as I get with implications on that, but I think that that's useful. Sort of zoom out and go to the more sort of general perspective on the statutory drift of the trade administrative state. I think I'm almost entirely convinced by the descriptive story that Tim and Kathleen tell. I think the introduction sort of tells us that we're going to look at trade authority, trade actions, and there's a bit of a mention of economic sanctions, but they kind of drop out. And I'm not sure how much the development that I told in the discussion of Aditya's paper from TWIA to IEPA, et cetera, interfaces with this story about the growth of the trade administrative state. It's obviously run out of a different office. It's done differently, but maybe there is a broader historical story there. On the point about judicial acquiescence, in a way that's entirely right, but in a way, maybe is it too soon, right? So I'm thinking of a lawfare post by Elena Chachko on the TikTok cases, where the argument she makes is that this could be a tipping point of its own. Whereas if we see the executive acting in more spaces like shutting down TikTok and doing things that are recognized as being like sort of a field from traditional national security, a field from terrorism, which wasn't always traditional national security but has become so, then maybe we will see a heightened level of judicial scrutiny. And so that's one possibility for the future. I'm not sure I'm convinced, but it's definitely a counter-argument. On the normative part, the orientation of the paper in general is about empowering Congress. And here, I'm not sure all the reforms do that, right? I think that's sort of the trick. One of the most fully, so I'm going to sort of take things in reverse order. So one of the most fully developed reforms is the judicial reforms, sort of improving judicial oversight. There's some language in the paper that seems to suggest that the Court of International Trade's specialization is itself a problem, but I don't think you mean that. I think it's really the Federal Circuit's lack of specialization that's the problem. And running this from the CIT up to the DC Circuit, though maybe not the 5th or the 11th Circuit, is a better idea. And I see the case for that, but I'm not sure how it empowers Congress, right? I mean, on the one hand, we might get decisions that are faithful to congressional intent, as in the Turkey case, right, where you see what Congress was trying to do with the time limits and you impose the time limits, but equally you might get decisions that are faithful to constitutional original meaning, or the court's own conceptions thereof, or the court's own assumptions, as we heard in the last panel, about what Congress intends, which is really not about faith to congressional intent, but it's really about faith to a certain sort of idealized theory of lawmaking. And I'm not sure that empowers Congress, right? And I think these critiques apply a fortiori for Supreme Court review, which the last sentence of the paper suggests would be salutary. Surely, I think you think it would have been in the American Institute for International Steel case, but like, how broadly do we want to read that, right? I think a lot of the, Supreme Court's doctrinal interventions, like the major questions doctrine, have been argued by many critics to be anti-Congress, not pro-Congress, even as it's purporting to validate some theory of congressional intent. On the administrative reforms, that part is currently unspecified, so I took the opportunity to do something very 2009, and I made a 2-box matrix, because the discussion of the growth of the trade administrative state is all about really the movement and shape of competence, and it seemed to me that there were 2 variables. One is whether competence over trade is distributed across agencies or whether it's concentrated in a single agency. And another is whether the agencies that handle trade are generalist, in that they handle other things too, or specialized, in that they're specialized on trade, right? And the reason it's a 2x2 matrix is that the current model, at least as you describe it in the paper, is a distributed specialized model. USTR leads, but there's trade competence all over the government. There was a quote in there about that, right? A concentrated specialized model would sort of bring all that trade competence into USTR. You say it's grown from 28 to 250 employees, but that actually makes it about as small as OFAC, right? And so, so it could be a big lumbering agency, like a Ministry of Trade in another country, right, where all that competence is housed in one place, right? But more generalist models, you could have interagency coordination. I'm thinking of Jody Friedman's work on agency coordination and shared space without, a designated specialized lead agency. Or you could have a generalist agency take over the lead and concentrate the expertise like it used to be in state in your telling, right? And maybe thinking about those sort of variables and then recombining them might be one place to go with that section. And then finally on the Congress point, there I'm less critical, but I do think there you have to maybe talk about your normative priors a little bit, right? Sure, there's a bipartisan desire on Congress to retake trade lawmaking, but to what end, right? Is it to slow down trade lawmaking? I mean, I think prior to 2016, that could be a very valuable end. There seemed to be a real disconnect between the bureaucracy and maybe the country about what the desirability of going forward with new free trade agreements. Is that still the case? The Taiwan example suggests maybe it is, but maybe not. Is that what we want to do? Are we vindicating more abstract principles about the separation of powers? Are we trying to force some kind of process that is a salutary process, right? What's the goal? At the same time, there are all these problems. There's the sort of rock so big problem. Congress can't make a rock so big, even Congress can't lift it. And so if the president acts in absence of Congress's authorization, Congress will deal with that, including by acquiescing in the future. It's interesting that the Taiwan response does not exactly equal your proposal for what Congress should do, which is like itself like an interesting data point. Why not just say, this is a good precedent, what's wrong with the precedent? In my sort of world on sanctions, I ask people who defend sanctioned entities whether they want Congress to be involved, and their answer is uniformly hell no, right? We would rather the courts be more receptive to our arguments, but the executive and the courts are where we can do work, and whenever Congress gets involved on sanctions, it has been bad, e.g. the recent certain Iranian assets case at the ICJ. So the to what end point I think might be different. Also, I wonder if you can maybe get more granularity by thinking with Jack Bierman on congressional administration, with Jack on the accountable presidency, so the various informal mechanisms by which the branches or the public, branches influence each other or the public influences the branches. I'm thinking of Nomi Lazar's work on the topography of emergency powers at a sort of higher philosophical level. So with that, I think I'll stop. I think I've probably gone over time. So thank you for two great papers.
I thought we might begin the panel discussion part of the session by inviting Aditya and then Kathleen and Tim to respond to each other's papers and to respond to Ben's comments.
Thanks so much. Yeah, thanks. And thanks, Ben, for such great comments. I think that they're really helpful, and we'll be working to incorporate them into the next draft of the paper. And just to remind everybody, I think hopefully I'm characterizing this correctly. Feel free to interrupt. But the basic point is that there can be a distinction made between freezing assets and seizing them that could have been baked into the law, the statutory scheme from the get-go, and then through many iterations, but perhaps was actually departed from. I think you mentioned in the Patriot Act, or conceivably,
a little bit.
We'll have to look into it, but I think this is a good thing to track down. And the paper at the moment deals with this issue through the Sardino case, as Ben mentioned, and just in a footnote. So I agree this should be expanded out. And the footnote points out that Judge Friendly in the Sardino case rejected the government's reliance on this distinction because he said, well, you're claiming to freeze these assets, but let's get real here. pointing to some takings cases with which, I'm superficially familiar. They'd be outside the scope of the project a little bit, but relating to regulatory takings, and this is effectively a taking. That's the reasoning in a nutshell. So there are other cases, not just Sardino. There are other cases that are takings or due process style challenges to IEPA orders, and they rest on similar reasoning about the temporary nature of this. And I was trying to point to that as, what else could justify this framework when I said, could it be that the government can place temporary barriers on transfers outside the United States, and that's somehow different from the seizure itself. But really great thoughts, and I very much appreciate the timeline on which I took notes, and we'll go revisit all of those statutory amendments to see if they can be made part of the story. But I think, as you say, like a separate part of the paper that just, if not, opens up a discussion of regulatory takings, because I think that would just be too broad, too big for at least points in the direction of like that could be a separate justification for some of these authorities.
Kathleen or Tim?
Let's see if we agree. Great. So Ben, thank you so much. As always, helpful and thoughtful comments. I appreciate very much. So let me take them in no particular order here. So on the, I think toward the end, your matrix. Love the matrix. So great. So I think those questions about institutional design. I mean, I would say firstly, we can't rewind. Right, this trade administrative state that we have, and we would not suggest that. So it really is about managing what we have, and the dangers you raised, the dangers of Congress being too interventionist here, which is why I wanted to start with the anecdote about Taiwan, because I think there was a question: does Congress want to reclaim this? And I think the answer is yes. If we can generalize so much, this may be one space where we actually can, but there are dangers of doing so. So we're cognizant of that. So I think that's why we. Although we haven't written up the administrative prescription sides yet, it really will be more about sort of the process, and unsurprisingly, as you know, think a lot about process. So where is APA appropriate? Where is something like report and wait appropriate? What sort of tools in the administrative law toolbox can work here to serve congressional interests writ large on the power? So that's the first thing I would say. The second, on your point about, do the prescriptions that we do have so far empower Congress? And I think just on the judicial one, right, I think there are two different buckets here. The first is the bucket where we have the statutory protections and they get overrun. And that would be the instance in which, you would hope that the circuit could police that better. The second then is where Congress has not given enough oversight, right, and we could put agreements in that space, or where they have not given any authorization in the first place, right? And in those instances, then the courts are not as helpful to us, either because we have standing problems, or we just, right? So that's the sort of, the courts are only useful in part of the story, I think, I would say. And the rest is, or they're the second best option, right? And the political barriers in Congress making a move are the bigger problem. Then lastly, just two little things. One is on the normative priors bit. Yeah, I think we've gotten this question once before, and I do think it's worth pointing out that this problem predates these two administrations and this particular trade policy. So we can date back to the, all the way back to the Obama administration. And we can go back at least before this, we'll call it protectionist turn in our trade policy, to say Congress was concerned then for different reasons. But so I at least am reluctant to sort of, go down that road too explicitly, at least in this piece, because I think our point, again, is more about process and good governance principles than it is about, trying to drive a particular policy. But no doubt that is in the background. And thanks, also for raising the question about, like, for example, is OFAC in the trade administrative state? And I think yes, but there's no question that the way, and which is something we try to highlight with the piece, that the way that these security, what we think of as security agencies act, it complicates this analysis. And that's really what we hope to get into, I think, in greater detail in the coming weeks.
Yeah, I agree with almost all of that.
Oh, good.
So I'll just say maybe two things. One thing that maybe you didn't pick up on. So your point about are the TikTok cases different, I think, is a really important one. We're going to hear a little bit later about TikTok and the specific provision in IEPA that causes those cases to come out the way they do. I do think the government's position in those cases, which is basically we get to ignore what seems to be pretty clear statutory language, and we talk about this in the paper, right, is consistent with the position they take in these other cases, and is concerning. And the way that entire TikTok episode sort of played out, I think, is not reassuring necessarily about this. And Anupam is going to, I think, talk about this a little bit more later. But I do think that, those cases were not going through the CIT in the Fed Circuit. They were going through basically the DC, DC courts, and would have gone to the DC Circuit. So I take that to be like those courts are a little bit better at reading statutes and saying this says you can't do that, and so you can't do that. I think that does, as Kathleen suggested, sort of give us some comfort that the courts actually would. There's a way to at least move courts in the right direction by sort of reallocating at least appellate jurisdiction. The one thing I will say, and we'd have to flesh this out a little bit more, but I actually have suggested that the trade administrative state could be reorganized. So in the run-up to the 2020 election, with a former colleague, we suggested basically not USTR, but rather the Commerce Department as we gave it some sort of unwieldy name that I can't remember, the Department of Economic Growth and Security, I think. And the idea was that you would concentrate, similar to your matrix, you would actually concentrate rather than distribute these specializations. Senator Warren proposed something similar in the 2020 campaign. So it was an idea that in connection with this resurgence of industrial policy, I think had some legs. But we have not talked about this in the context of developing these sorts of reforms. But that certainly was something that was in the air, a few years ago. And there is, in the context of industrial policy, there is actually, again, kind of a bipartisan interest in how you would make government policy be more effective at the nexus of domestic and international, domestic and foreign commerce to promote a variety of values like supply chain resilience and all these things. That's a longer conversation, but I do think the bipartisan consensus on reclaiming Congress's role does extend to an interest in at least thinking about these kinds of issues.
Maybe I'll follow up by asking a question to each of you. Okay, so Aditya, you have a sort of, we go from embargoes to TWIA to bank holidays to, national economic emergencies, a sort of war to peace story about when sanctions are appropriately imposed. And I wondered if there was a different story you could tell that's sort of more New Deal oriented that says something along the lines of it was ever thus. And so there you'd begin with the Export Control Act of 1940. You'd add to that the Export Control Act of 1949. Then you'd talk about the rise of CFIUS and Congress's, since 1980, regular 10-year reauthorization of this process. Why isn't that the right way to think about imposing sanctions in sort of peacetime contexts?
Yeah, so just off the top of my head, and correct me if I'm not understanding the question correctly, maybe one way of looking at this is that, sure, there's TWIA that at one point was specifically targeted at wartime, but there are all these other authorities that were peacetime authorities and involved a significant regulation of the economy.
Yeah, and the idea is that's where our settlement today comes from.
That could be the baseline. I don't think that the paper necessarily has a dog in that hunt, other than I suppose what I took as a given are the underlying constitutional individual rights protections, whatever they might be, because you might say, as Ben pointed out, that the protections for property apply only to seizures, and they don't apply to freezing assets because that wouldn't qualify as a taking of property. But whatever that scheme is, however robust those protections are, I thought of the prize-style cases as being exceptions to those. And then TWIA builds off of those cases and says, none of those protections are going to apply now in this, under this new statutory scheme that we're creating. Sorry, that's actually a little bit too strong of a way to put it. Instead, I think what TWIA does is it says, during this new war, those old defaults, we won't use them exactly. Instead, we're going to codify new defaults during wartime that would otherwise potentially implicate these protections, but the protections don't exist because we have an exceptional state in this instance. So that's the way in which I think kind of the narrative fits for me. But I'm very curious to hear your thoughts, anyone else's thoughts, because maybe you'll have pushback on that point.
I'm not sure if this is pushback or functionally, don't we get a lot of protection for American property rights out of the American view that prompt, adequate, and effective compensation is something to which people are entitled, and we want foreign countries to offer that to American investors. Is that some sort of functional reason not to worry too much about the due process concerns that you've raised?
Maybe we'd have to think about that a little bit more. But one sort of concrete data point here that actually, in some ways, was the prompt for some of this project is the challenge to CFIUS that occurred in the Rawls Corporation case. So this is about 2015, and that's a due process challenge to CFIUS. And in that case, and this perhaps goes to, are the TWIA and IEPA kind of like exceptional statutes, or are they kind of on the same plane as CFIUS? As I recall, the governance brief in the CFIUS Rawls Corporation case doesn't rely on any of the reasoning here. So it relies instead on like standard issue takings principles and due process principles on which you're probably aware, and maybe people in the audience are familiar with this. The government ultimately loses, and there is some process that has to be provided, however minimal it might be in this context. So I think it's a very interesting question, and I think it goes to, right, what do we think of as the baseline, and is TWIA just departing from that baseline, or IEPA departing from the baseline, giving additional authorities that allow you to sort of get exemptions from whatever the protections are in the and now it's like wartime hostility, emergency context, or would we just say that the baseline provides for all this, functional style reasoning? And maybe that intersects a little bit, because I thought about this with, are there some other justifications? And again, without getting too deeply into takings law, some people have written articles on how there could be an emergency or a conflict-style exception to takings law, about which I'm hoping not to say too much. But if that is the baseline, then TWIA is just the same thing in a way. Yeah.
Is it all right if I jump in on that real quick? Yeah, I think it's useful for sort of folks to understand the idea of prompt, adequate, and effective compensation as being tied to takings. For those of you who aren't familiar with this area, the basic U.S. policy and its investment treaties and its view of customary international law is that a taking of property requires prompt, adequate, and effective compensation. It also requires due process, right? But the absence or presence of due process does not do anything to the requirement of compensation. You must compensate for a taking. That's the rule. And so the thing that I sort of struggle every year to teach to my investment law students is, so if you want to pay $0, what do you argue? You argue that what I just did is not a taking, right? And I think that one of the things the freeze versus seize thing was originally designed to do is to argue that what we're doing is not a taking. And even if we're depriving you of the use of your property for some period of time, it's in the service, like Aditya said, of police powers under an emergency, et cetera, et cetera. And so what we're doing is we're not doing a taking that triggers the compensation requirement. And so I think like that might be a potential response, David, is like, well, yes, we have that policy and we want all countries to follow it, except for us when we do this to you, Ray.
Okay, a question for Tim and Kathleen. So this is kind of sort of a functional question, rooted in like Elena Kagan and Posner and Vermeulen stories about like the executive branch has to be the actor. How would Congress, so it's one thing to say Congress should authorize trade deals with Taiwan. I get that. How would Congress otherwise supervise a trade negotiator? In financial regulation, there was a statute that passed the House which said, if you're going to go out there and negotiate a new capital adequacy statute, you have to come here and tell us what your position is going to be before you go out there and try to come up with a deal. And I think that statute failed because the idea was that would be completely unworkable, that you can't enter into a negotiation once you've identified then it's not a negotiation, it's a take it or leave it sort of inquiry because you've told Congress what your position is. We could go on, but how exactly are we supposed to empower Congress when you want somebody out there negotiating trade deals with foreign counterparties and having the flexibility to sort of get to yes and then go?
So first of all, a lot of U.S. trade deals are take it or leave it offers. So, functionally, much of them are just sort of copy paste. So that seems unproblematic, actually, in this context, at least much of the time. To the extent that, in the Taiwan legislation does, in fact, do much of what you just suggested, right? It sort of says, look, you've got to tell us what you're going to do before you go do it. You then have to tell us, what is your idea and what's their idea, where's this coming from? I think, the executive branch has these kinds of functional concerns. There is an existing system, and I think one of the things that so many people found objectionable about the way the Trans-Pacific Partnership was done is that there already is a system for lots of consultation. It's just basically run by the U.S. Trade Representative's office, and it's whoever has access to it is whoever they want. So with TPP, actually Congress, arguably, and members of Congress were saying, we have less access to and less consultation than members of industry. So it's not that the Trade Representative's office wasn't doing it. They were doing it. They were sort of tabling the sort of, here's what we're doing, here's the state of play. But members of Congress, their staffs couldn't even see the text unless they were cleared properly. They had to have, TSSCI type clearances. And so that's deeply troubling. It both suggests that the functional objection, that the executive branch itself doesn't really believe it when it comes to time to actually consult with whoever they want to consult with. But it's also troubling, I think, in that context that it's gone that far. And so, as Kathleen mentioned earlier, I think we do have a sense, there are, one of the houses of Congress is currently non-functional. So we're very aware of the potential dangers that could result from sort of excessive supervision, if you will. But at the same time, I think we really have in the last decade sort of tipped far too far in one direction, and this is about rebalancing in that sense. And the functional objection to that is, I think, often used to deflect any effort at reform at all.
100% everything Tim just said. I'll just add maybe two things. One is, he and I have said publicly that we did think that the Taiwan bill, which goes farther than anything before, was perhaps impractical or difficult and may impede the executive's ability to get a good deal with Taiwan. So we have said that. But I think the general question is not so much how to supervise the trade negotiating team, since that has been happening in the big free trade deals over time, as he explained, but really the fact of which sorts of deals get which sorts of supervision. And that's the type of thing that's the question that I don't think anyone has yet answered, that Congress is working through. That yes, there are certain types of trade deals that require, where Congress wants a heavy hand. There are certain types of trade deals where Congress is happy to have the executive go forth and conquer and do its thing. And so that line drawing exercise is where we're very much concentrated right now.
And if I could just say one thing, because this is going to be relevant to a paper on the next panel, which is, Kathleen has done an extraordinary amount of work documenting trade executive agreements, that is trade agreements that are not going through Congress and for which the authority is vague, nebulous, and often non-existent. And so, it's tempting when we come to kind of step into the public square to think we're always talking about things like NAFTA or TPP or the World Trade Organization. But actually, that's most of the time not what we're talking about. Most of the time, what we're talking about are really specific granular, I should say, most of the time what trade lawyers are worried about is really specific granular agreements that it might make sense to have sort of different processes that apply to those as opposed to the sort of economy-wide sweeping type agreements that make it to the front page of the New York Times.
Your moderator has not left much time for questions, but there's a little, so please head on up to the mic if you've got a question or a comment. In the meantime, I will read a CLE word. Sanctions is your CLE word. So. Any questions or comments? Yeah.
Sorry. Write down the CLE word. Just a quick question on standing. I understand that an aluminum company, an aluminum foil company, has standing to challenge the delegation of authority from Congress to the executive branch. Do I, as a consumer who buys aluminum foil, have standing?
I think the consumer probably has the injury is probably not particularized to you in a way. If you're just paying essentially a pass through on essentially you're saying the price has gone up because there was a tax. Right, so the economic reality is real. Right? You are in fact paying more. You could have, and I suppose it would matter where in the supply chain you were. So if you're just like an end-use consumer and you're like my Coca-Cola can, my Coca-Cola is a little more expensive because of the can, I'm not sure that person has standing. If you are literally the person in the supply chain who's sort of actually importing the goods, first of all, you would definitely have standing if the incidence of the tax were to fall on you or potentially were to be sort of displaced onto you by a contract. And then I think the further away you get from that, the more likely you are to have some sort of issue with just having a generalized grievance that's just not sufficiently related to where the tax itself is actually falling. But that's my off the top of my head response to that question.
Thank you.
Great. Well, why don't we call victory 20 seconds early, and I'll send you guys. Oh, okay, sure.
I would like to know the seizures that the government does for companies or business, like drug cartels, got those vacant mansions. So can we get those vacant mansions if they? That's what I want to know. When they seize the mansions and drugs and the Maserati and the BMWs, that's what I want to know.
That's a taking, right?
Well, so Ben might be more expert on this than I am, but what I would assume would happen in that case, it's not within the scope of these statutes that we're discussing, like the TWIA and the IEPA, but rather it would be under the government's standard criminal style authorities, and so that they would use ordinary forfeiture laws, and all of the constitutional law that surrounds that would be applicable.
Yeah. I mean, that's my understanding too. So what we're talking about are these national security powers that allow freezing of certain assets of terrorists, but also drug cartels and hackers and all sorts of other people. But a lot of this stuff you're talking about falls under the category of criminal forfeiture, which is in a different universe. And I mean, my understanding is, yes, you can buy it at a foreclosure sale, except for the drugs. You probably can't buy those.
Right. Yeah.
Can't buy the drugs. All right. Thank you all for an excellent panel, and thanks to the audience as well.